also published a book on employees' trust at the same time, and he pipped me at the post because his had a foreword by one Andrew Thornhill QC. Now, those are two names that are going to crop up time and again through these lectures. There was something else that happened in 1989, and that was that there was a change from an accruals basis to a receipts basis for the basis on which income tax on earnings fell to be charged. And that was quite critical because it set off an opportunity for taking advantage of a timing difference. Up until then, employee trusts, and by an employee trust, what I mean is a discretionary settlement for a class of beneficiaries who are defined by reference to employees of a company or a group of companies. It typically has an offshore independent trustee, and they were becoming commonplace amongst listed companies, not for tax reasons, but because a listed company couldn't then hold shares in treasury. And in order to prevent dilution when it issued new shares for employee share schemes, it established an employees trust, which was then used to purchase shares in the market pending distribution on the exercise of share options and the like. So in those days, it was mainly listed companies that established these forms of employees' trusts. Now, at that time, it was quite clear that under general rules, any contributions made to an employee trust were deductible if they were not capital payments, and provided they could be shown to be incurred wholly and necessarily for the purposes of the company's trade. And there was plenty of case law to support that. Heather P. Consulting, Jeffson Rington's, E. Bottom Price, to name but a few. Now, Section 43 of the FA in 1989 did try to modify that. It provided that unless emoluments were paid to an employee within 9 months after the year end, there was no deduction allowed when they were paid to the trustee if they were relevant emoluments. In other words, if they were monies allocated in respect of a particular employee or generally in respect of employments, and they were amounts held by the trustee with a view to becoming such relevant emoluments. Now, this wasn't worded very well, and many advisors persisted in the view that notwithstanding under general rules, contributions to a trust, if correctly structured, was still deductible to the paying company. And that was supported by a letter that was published in the Law Society Gazette from the Revenue, confirming that notwithstanding Section 43, they would still accept that normal contributions to an employee's trust were deductible. Now, following the publication of particularly the Baxendale Walker book, a number of larger listed AIM and city firms were advised of the perceived benefit of avoiding tax on bonuses, typically very large bonuses paid to senior executives. Instead of paying a bonus subject to PAYE, what they could do was make a contribution of that amount to such a trust. That was supposedly deductible when it was made. There would at that stage be no general earnings charge on the employee, but the trustees could choose to make a loan which would, under the rules at the time, be taxed as a benefit in kind by reference to interest at the official rate. Now, it didn't take long for the message to be spread amongst all these larger companies that here was an opportunity not to be missed. So typically what happened was that the board would determine at the end of the year the size of an individual's bonus. An offshore trust would have been established. It was funded by contributions made by the employer company to the amount of the putative bonus. And then either the trustee, acting on the recommendation of the settlor company, would make a loan to the employee on commercial terms, or possibly the trustee would first appoint the funds to a sub-fund or a sub-trust for the individual, and it would be the sub-trust that would then make the loan to the individual. And in effect, the loans took the place of bonuses and other discretionary remuneration. So at that stage, it was widely accepted that any payment received from an EBT was taxable. Brumby and Milner, Hochstrasser and Mays, to name but a few cases, which made this quite clear. But there was no suggestion that the employee was taxed on a payment into the trust, even if that payment was earmarked for the benefit of a specific employee. It was presumed that as an employee was only a discretionary beneficiary, he had no right or entitlement to any payment or benefit, so there was no charge until payment was made out by the trustee. But the trust contribution was arguably still deductible for corporation tax purposes. No tax when the contribution was made, as I say. The loan was taxed simply as a benefit in kind. And if the loan remained outstanding when the individual died, it fell outside his estate for inheritance tax purposes. And indeed, some thought at that stage that the money could then be paid out free of income tax to a surviving relative. Now, in the case of close companies, there were some concerns because there were inheritance tax pitfalls. So if a close company made available, paid away a sum to an employee's trust, arguably that was a transfer of value, giving rise to charges under Section 94 of the Inheritance Tax Act. And it was, in order to avoid that, the trust had to be structured as what's called a Section 13 trust. In other words, it had to provide that no benefit could be made available to participators in the company or connected persons at any time. There was an argument that, and this was posited by Mr. Baxendale Walker in particular, that it could be structured so that benefit could be paid out after a principal participator had died to someone who was not previously a participator, and a lot of structures were put together on that basis. But as that theory was very recently debunked in a case called Barker and the notorious Mr. Baxendale Walker in 2017. Now, a number of advisors sought to push the boundaries of these sort of EBT loan schemes. I think the most egregious one that I saw was where a company was encouraged to contribute to an employee's trust a sum equivalent to 3 years anticipated bonuses for directors. The trustee then loaned the amounts back to the directors, but on condition that they in turn loaned the money back to the company. So the money went in a complete circle. And the idea was that each year the company would repay the loan to the individual, this cash transfer avoiding PAYE tax and NICs, but the loans from the EBT to the individuals would remain outstanding indefinitely. Now, in 2003, we then had Schedule 24, which rather tightened up the rules restricting deductibility of contributions to an employee's trust. But even so, there was still an opportunity to argue that a contribution was deductible if the trust was structured as an EFERBS. Schedule 24 wasn't ideally drafted, and there was a suggestion that if a benefit was provided in the under the terms of an EFERBS, then that qualified for an immediate deduction. And that was why a practice developed of structuring these employees' trusts at that time as EFERBS. Now, up until 2004, this wasn't the only form of tax planning that was going on. Some of you may remember the idea of paying bonuses in the form of platinum sponge so as to avoid NICs. The revenue and the government were getting increasingly frustrated about this. EBT loan schemes were costing an estimated £2 billion to the Treasury. What could be done about it? Well, in 2004, the government introduced the DOTAS rules. The problem with that was that in relation to EBT loan schemes, they had become so part of the mainstream that they didn't always fall within the hallmarks that necessitated disclosure of the scheme to the revenue. But perhaps the high point was on the 2nd of December 2004, when Dawn Primarolo, the Treasury Minister, made a written statement to Parliament giving notice that the government would introduce retrospective legislation to tackle any avoidance scheme that came to light. And this was believed to be quite a turning point in the government's approach. It was portrayed as a sort of an attempt to halt the arms race between advisors and HMRC. Meantime, certain QCs, other lawyers, accountants, trustees were all generating very substantial fees from advising upon and implementing EBT loan arrangements on the understanding still that the contribution was deductible when made, that the employee was not liable to tax on earnings, even if they were earmarked for the benefit of that particular employee. The reason being that it was said the employee did not have practical control over the disposal of the funds, per Aberdeen Asset Management in 2013, or it was argued the money was not placed unreservedly at the disposal of the employee, per Garforth New Smith Stainless 1979, and applied again in Sempra Metals, or it was argued the fund simply didn't belong to the employee. Whichever way you looked at it, it was argued very strongly that there was no payment of earnings and no charge to tax at that time. Of course, from the employee's point of view, the uncertainty lay in the fact that he didn't actually have the money. The money rested with the trustees. The trustees had merely made a loan. At some point, that loan could be called in or become repayable. But that was allayed by ensuring that the funds and the benefit of the loan was put into a sub-trust or a sub-fund. The individual employee could be appointed as protector to that fund, so that in effect, indirectly, the employee had the confidence of knowing that those funds were ultimately available to him, or in the event of his death, his family. And so in the period 2004 to 2010, many accountants or advisors were all led to believe that this had become mainstream tax planning. After all, it was asserted, it had been confirmed by the opinions of leading counsel, so it must be correct. Well, HMRC was certainly not taking that line. But the problem was they weren't actually raising any challenges to the declared tax treatment of the loans, despite issuing DOTAS numbers. They were fully aware of what was going on, but so far as I could see, they were like rabbits frozen in the headlights. Now, at this stage, I ought to just flag up that not all practitioners were of the view that this was the correct view of the law as it stood at the time. Some of us were of the opinion, and were later vindicated by the Supreme Court in the Glasgow Rangers case, that if in substance what is paid away by the employer is for the services provided by a specific named employee, then it properly falls to be taxed as PAY income at that time, regardless of to whom it is paid or how it is described. But it's fair to say that back in those days, it was not our voices that were heard. That situation could be distinguished from that in which contributions, whether or not deductible, are made to a general fund with no immediate allocation to a named employee, no immediate intention to provide benefits until what is only a contingent entitlement has become an unconditional entitlement. And there's plenty of authority for that in a case called Edwards and Roberts back as far as 1935. And later, that position was also confirmed by the Supreme Court in Ford and McHugh in 2014. Now, just moving on to 2010. Until late 2010, there still appeared to be no positive action by HMRC to put a stop to what had then become a widespread practice amongst employers, not merely the large listed companies and city firms, but right across the country, and in particular, owner-managed businesses. The loss to the Exchequer in 08-09 was estimated at 1.1 billion, rising to 1.54 billion in 2011-2012. But then three things happened. First, in October 2010, HMRC commenced action before the First Tier Tribunal against Glasgow Rangers Football Club. Secondly, HMRC began to work in earnest on legislation intended to bring a halt to this form of tax avoidance. And thirdly, HMRC began to issue so-called spotlights. Those were bulletins aimed very much at advisors rather than end users of these schemes, highlighting that in HMRC's opinion, EBT loan schemes simply didn't work. Now, as regards the first of those, the Glasgow Rangers Football Club, in common with, it must be said, many other football clubs, had set up what they described as a remuneration trust, which was no different from an EBT, back in 2001. And it had adopted a widespread practice of whenever a company wanted to recruit a player or another employee or even a supplier, instead of making a payment, what it would do is make a contribution of that sum to the trust and then ask the trustees that the sum be paid to a sub-trust for specified members of the individual's family, and that it be applied in accordance with the individual's wishes, typically by way of the trustees extending a loan to the individual or a member of his family. That would be repayable as to capital and interest after the individual's death, so again reducing the individual's estate for IHT purposes. No income tax or NICs were accounted for on the loans. The loans would be disclosed and tax paid on the basis that it was a benefit in kind, relatively a modest sum. Now, bear in mind that at that time, HMRC were contending that PAYE and NICs were due from the employer, not at the time a contribution was made to the trust, but at the time when the trust extended the loan to the individual. The third thing, or the second thing rather, was the preparation of the draft legislation. What many of us as advisors had expected was that the government would introduce rules very similar to the loans to participators rules in the case of closed companies. In other words, insofar as a company puts beyond the reach of its creditors by making a payment, a sum of money to a trust, there would be an immediate requirement to deposit tax at quite a penal rate, possibly as much as 54%, with the revenue, against which credit would be given when benefits were paid out of that fund in a manner which was subject to PAYE and NICs. That would have been fairly straightforward to understand and to apply, but that's not how it turned out. I was shown a sneak preview of the legislation in 2010, and along with others was quite shocked to see that how convoluted it was, because we were told ministers had dictated that this be perceived as a tax charge on employees, not an additional tax charge on employers, since that would have not gone down well politically. So on 31st March 2011, the draft legislation was published. It was put out to consultation, and a lot of us raised our hands to show that this was going to catch an awful lot of situations which were perfectly commercial. There's nothing to do with tax avoidance, and it really ought to be reduced in scope. I have to say the revenue were slow to respond. There were a number of exclusions included, but these were all on a very piecemeal basis, very tightly drawn, and it certainly went nowhere near what we were hoping would be the limitation on the scope. Now, at this stage, the legislation applied only to employment situations. It was ultimately enacted on 19th July 2011 and had effect from 6th April 2011, although there were some forestalling provisions which took effect from an earlier date of 6th December 2010. It's worth noting that since then, the legislation has been amended, reenacted in part, added to every year except 2015, and in 2017, twice in 1 year. It now amounts to over 80 pages of legislation, and although the main case is headed employment income provided through third parties, I would say this is rather misleading, because there are certainly circumstances in which a charge can arise, notwithstanding that no income or benefit is actually received. Now, overlaying that, we have the loan charge, which Keith will describe. That's a one-off charge on 5th April 2019. Now, before I go on to describe the legislation, a bit of a health warning. It's a highly complex piece of legislation and full of traps, and what follows can only necessarily be an introductory overview. It's clearly not legal advice. You always have to think of whether, and if so, how these disguised remuneration rules, as they're called, might apply before advising on a specific arrangement, actual or proposed. It can and does catch perfectly commercial arrangements which have no tax avoidance intent, and a little bit of a plug, a telephone call to counsel just to check could save your firm and its insurers a substantial amount, and certainly some reputational damage. How's it structured? Well, we've got the main case. Section 554 has a gateway through which, if you pass, the provisions then apply. And then you've got sections 554B to 554Z15. We've got the close companies case, which was added later and relates to steps taken from 6th April 2018. That's in section 554AA. Then, as a separate set of legislation, which is in ITOIA rather than ITIPA, we've got what's called the self-employed charges. Here you've got a gateway provision, section 23A of ITOIA, and if you come through that, then the charging provisions in section 23B to 23H. There's also, and I just mentioned this in passing, some rather odd provisions in sections neatly numbered 554Z16 to 554Z21, which relate to a situation in which an employer earmarks or provides security for an undertaking given in relation to the provision of pension benefits. That's pretty obscure, and I'm not going to say further about it. The outstanding loan charge provisions are in a separate piece of legislation. They're to be found in Schedules 11 and 12, Finance Number 2 Act 2017. First, some key points. Always remember that the disguised remuneration rules take precedence over all other charging provisions. The main case does not catch loans or benefits provided directly by the employer or another member of the same 51% group, unless the employer or another member of the same group does so in a fiduciary capacity as trustee. But generally speaking, if a loan were to be made by an employer company to its employee, that of itself is not within the scope of DR. You have to have the involvement of a third person, but that third person can include the employer if the employer is acting in capacity as a trustee. It's unclear whether that also means acting as bare trustee. I think the intention was that it acts as a trustee in the sense that that is used in the context of the settlement provisions. Under the main case and the close companies case, where a relevant step is taken, then the value of that relevant step is treated as employment income of the employee or the individual concerned. That amount is PAYE income, so the employer is primarily liable to account for tax and NICs under PAYE. And furthermore, it's treated for PAYE purposes as a notional payment. That's very significant because it means that unlike other PAYE liabilities, if after 30 days from serving a Regulation 80 notice on an employer who has not paid over the tax remains unpaid, then HMRC can recover the tax and late payment interest directly from the individual. So it skirts the normal safeguards that apply in relation to PAYE income, where HMRC have to show that the employee knew the employer was in willful default in not accounting for the PAYE. The loan charge, in particular, can also be recovered directly from the individual if the employer is outside the UK. Now, a disguised remuneration charge by reference to a given amount doesn't mean that the employee is then relieved from unpaid tax on any earlier charges by reference to the same amount. So if you remember, HMRC were of the view that a loan was, when a loan was made by a trustee, that was the point in time at which a tax charge arose. Of course, ultimately in 2017, the Supreme Court held in the Glasgow Rangers case that wasn't so. The time at which a tax charge arose in the normal case was when what they described as redirected earnings were contributed to the trust. They took the view that, certainly in the fact situation of Glasgow Rangers, what was paid over was for work done as an employee. It was therefore remuneration. It didn't matter that it was not paid directly to the employee. It was paid to the trust, either with the acquiescence or agreement of the employee. And therefore it was that earlier point in time at which the tax charge arose. Now, the revenue are still persisting in saying that even if a DR charge or the loan charge subsequently arises, that earlier charge still holds. And of course, if the revenue are in time to assess that earlier charge, they will seek to do so. There are fairly complex provisions which provide that if tax is charged under a DR charge on an amount which has been the subject of an earlier charge, then you can gain credit for the tax paid on one of those two charges against tax owing on the other. But those are not very generous in their scope, and you can end up in a situation where, because there is still an earlier tax charge outstanding, even if it cannot be collected, overall the amount of tax paid by or payable by the individual will be disproportionate to the benefit that was first paid over. And if they're in time to do so, HMRC will certainly seek recovery of those earlier charges. Now, how does the DR legislation work? Well, I think it's easiest to think of it in terms of 5 steps. The first step is, do the circumstances you're faced with come through the gateway provisions? Now, the main case gateway, section 554A, I'm just going to summarize it for you because it'll give you a flavor of this legislation. It refers to a situation in which there is an arrangement which relates to an employee, A. It's reasonable to suppose that in essence it's a means of providing or is concerned with the provision of rewards, recognition or loans in connection with A's employment with B. A relevant step is taken by a relevant third person, and it's reasonable to suppose that in essence it's taken in pursuance of the arrangement or there's a connection with it. And for these purposes, all relevant circumstances are to be taken into account to get to the essence of the matter. Just pausing there, you can begin to see that this is a whole new style of statutory drafting. It's far removed from the tax law rewrite style. Throughout this legislation, you'll see phrases used such as "for example" or "about." When it refers to a period of time, that period of time begins on or about and ends on or about. There's no certainty. So we can generally advise with some certainty as to what is caught by the legislation. Where the uncertainty arises is it's often very difficult to determine what is not caught by this legislation. We then have, in relation to close companies, they have a separate gateway, which is rather different. That applies to relevant steps taken by a relevant third person from 6th April 2018, if related to a relevant transaction by the company, and either there's a tax avoidance motive or the avoidance of loans to participators charge is what is intended. And it only applies where the individual is or has within the last 3 years been a director or employee and had a material interest, that's a 5% interest in the company. But the point and the reason why we have the close companies gateway is that it applies to situations where the benefit that's received, the loan or other relevant step that's taken, is not necessarily linked to the office or employment. It covers situations where, in essence, it's an extraction of profit from the company rather than a payment by way of reward and recognition for the employment. So that's step 1, the gateway. If you don't come through the gateway, you're not within the scope of these provisions. Of course, in real life, it's rather like the test of what is an elephant. You can normally sense that the situation you're presented with comes through the section 554A gateway. You may not be able to put your finger on quite why, but there is a link with an office or employment. There is an arrangement. There is a connection between what is ultimately received by the individual and the fact that he is an officer or employee. Always play safe. Assume you come through the gateway unless you can show with some certainty that you have not. So step 2, is there a relevant step taken by a relevant third person? And if so, Was it in pursuance of the arrangement, or is there a connection between them? And a relevant third person here is anyone other than the employee or the employer, except, as I said earlier, it also includes the employer and the employee if they are acting as trustee. Now, what is a relevant step? Well, it covers, first of all, things called earmarkings. Now, I used to think that earmarking was what you did to a sheep to tag it with a number, but not so here. This is very broadly defined as where assets are held with a view to a later relevant step being taken in relation to them or to assets derived from them, or where someone, such as a trustee, begins to hold assets with a view to a later relevant step being taken by any person in relation to them or assets derived from them. And it doesn't matter if you haven't yet thought what that later step is going to be. But the property earmarked must be held by the person earmarking it. So, for example, it's no good a trustee allocating or earmarking a sum of money which they have not yet received, or shares for which they have not yet subscribed. For the earmarking and therefore the tax charge to arise, the person doing the earmarking has to actually have possession and ownership of the assets. But for the first time, we get a situation where a tax charge can arise simply because someone, such as a trustee, changes their mind, having held something on a general basis or on an unallocated basis. They decide that they are now going to hold a specific amount of money or an asset with a view to then providing a relevant benefit to an individual at a later stage. That change in mind technically can trigger an earmarking. Now that's just one of the relevant steps that are specifically defined. The next one is loans, any payment, any transfer of assets to a relevant person, or the provision of security for meeting a liability. Subsequently, they introduced another heading, the release or writing off of a loan. So you have a DR charge arising where, notwithstanding that a loan charge has arisen, that loan is then subsequently written off by the trustees. That is the occasion of another DR charge. And at that point, you then have to look back to see how the double taxation provisions work and whether, if you've paid tax on the earlier event, credit is being given for tax on the later event. Another relevant step, the acquisition of a right to payment of assets if there's a connection with a payment, loan or transfer. This one is specifically aimed at a particular tax avoidance arrangement which was put in place to try and defeat the DR rules. This was introduced from 2017. Then we've got procuring the acquisition by the employee of shares or share options or anything to do with securities. Then we've got another separate heading of allowing the use of an asset. So suppose, for example, trustees own a ski chalet and they allow that to be made use of by an employee pursuant to an arrangement for reward or recognition of his employment, then that may give rise to a DR charge, as will the grant of a lease, a long lease, 21 years or more, or under arrangements where it's likely that the lease will be extended beyond 21 years. So once you've gone through the list of what is a relevant step, there's then a whole raft of provisions which provide exclusions. So step 3, is the relevant step specifically excluded? Having done that, step 4, what is the taxable value of the relevant step? And step 5, is the taxable amount reduced by the amount of any relief? Just pausing there, the relevant step has to be taken with a view to providing benefit to a relevant person. And that's not only the employee himself, but any person linked with the employee or any person chosen by the employee or a linked person. Or if the step is taken on behalf of the employee or at their behest, then it could be anyone else. So, for example, if an employee chose to direct that the trustees pass benefit in the form of a relevant step to perhaps a favoured charity, that can nevertheless still trigger a DR charge, notwithstanding that the employee hasn't in particular benefited. Who is a person linked with the employee? Well, that's very widely defined as a person connected with the employee or a close company in which he's a participator or a subsidiary of that company, etc. But it also goes on to include anyone living with A as if they were the spouse or civil partner of A, which raises a very interesting question of the extent to which HMRC can come questioning who you're living with and whether you're living with them as if they were your spouse or civil partner. And a linked person remains linked after the death of the employee. But there's a subtle point to note here. A child born after the death of the employee is not linked, as they were never connected. And that may provide a little bit of scope for some planning. It's worth stressing that these rules can catch wholly commercial arrangements. There was a well-known bank which for years had operated a scheme whereby each year it allocated an amount of money that was paid into a trust that was invested into the bank's own shares, pending the retirement or good leaver situation when the employee departed, and those shares were then sold and the money was paid out. The earmarking of those shares when they were held in the trust was caught by these DR rules, which meant that particular arrangement could no longer be maintained because it gave rise to a dry tax charge at the outset. Now, I said there are a number of exclusions. It's a bit of an understatement. We've got sections 554E to 554Y. We've got 22 sections over 21 pages of legislation, all of them very restricted, very tightly drawn. Some of them are exclusions only from an earmarking charge. So always check to see that your relevant step, whether if it's not an earmarking step, then whether the exclusion actually applies. And you always have to go through very carefully to make sure that if you're relying on an exclusion, it's the right exclusion and that all the terms are satisfied. These exclusions include such things as certain commercial loans by a bank on terms similar to those offered to the public, certain general employee benefit packages where they're offered to substantially all employees, car ownership schemes, purchase schemes where you've got a loan that's been organised by the company and perhaps funded by the company to enable an employee to purchase a new car. Note, it's only new cars, not second-hand cars. If an employment-related loan has previously been made, the employer has been transferred to a new company on a transfer of employment, then you can get a technical DR charge arising in relation to the acquisition of that right to repayment of the loan on the part of the new employer. So that's specifically excluded. You've got a number of other very focused exclusions, so that, for example, normal investment income on earmarked assets would not generate yet further disguised remuneration charges as that investment income is generated. And likewise, if an earmarked asset is disposed of in a normal commercial transaction and rolled over into a new asset, that will be excluded. And there are certain pension-related relevant steps that are excluded. The revenue reserved to themselves power to make regulations to provide for further exclusions, and so far, apart from a very obscure pension one, the only one that's been put in place is for sporting testimonial payments, which are fully taxable. You've got to wait until you've read 25 pages of legislation to find the actual charge to income tax, and that's hidden away in section 554Z2. As I said, it's on the value of the relevant step. If it's a loan, it's the amount of the loan. If it's a transfer of an asset, for example, it's the market value of the asset. And that counts as employment income for the year in which the relevant step is taken. It's subject to PAYE, and it's a notional payment, as I said. So if the employer does not account for income tax under PAYE, not only can the tax be recovered directly from the employee, but if the employee fails to make good the tax to the employer before the end of 90 days after the end of the tax year, then you can get a further penal tax charge under Section 222. And a disguised remuneration charge is subject to national insurance contributions. Now, having worked out that you do have a relevant step, you've come through the gateway, you've got an occasion of charge, you know the amount of the charge, there's then a whole host of provisions which provide for adjustments and exclusions from the charge. These are very different from the exemptions that I've referred to earlier. So, for example, they take account of what happens in relation to an individual who's charged on the remittance basis. There's three whole sections to deal with that. There's a very important section which deals with a situation in which an individual has paid tax or his employer has accounted for tax in relation to an earlier event in relation to the same amount of money. So, for example, if the individual or the employer has settled with HMRC the earlier general earnings tax charge, then the amount on which that tax has been paid reduces the amount on which a later DR charge arises, typically to nil. But you have to look very carefully. And of course, this only applies if the individual or the employer has paid in full the tax that arose on that earlier charge. And of course, if they've refused to settle, that will not be the case. There are other adjustments and exclusions if, for example, the relevant step otherwise gives rise to a general earnings charge or an IR35 liability under Section 50 of ITPA, then again, there is a reduction. But remember, it's always the DR charge that takes precedence, and that may then be reduced. You cannot simply sidestep the DR charge by saying that some other charge takes precedence. It simply doesn't work that way. There are also some horrendously complex provisions in the very nattily numbered sections 554Z11B to 554Z11G. These are the ones that provide credit for tax where there are two successive occasions of charge. No tax has been accounted for in relation to an earlier charge, but tax is paid on a later charge, in which case credit can be given against the tax that's owing for the earlier charge. The problem is, of course, that there will be late payment interest on the earlier charge. The amounts, this applies only insofar as the amounts concerned overlap with one another and only in relation to the amount of the overlap. So in practice, it very often ends up that you still have an outstanding earlier tax charge, which if the revenue are in time to assess, they will happily do so. There's another provision that says that if you've got an earmarking, and that gives rise to a disguised remuneration charge, but the earmarking is with a view to a future relevant step being taken, but no relevant step is ultimately taken, then you can apply for relief from the earlier earmarking charge by way of a repayment of tax. Now, that's a very brief overview of how it works. I cannot stress too highly how complex this is. I've been writing a book on it. It's taken me all lockdown to even understand some of the detailed provisions. This is not the easiest fasciculus to understand. Now I'm going to move on to 2017. HMRC finally won the Glasgow Rangers case in the Supreme Court, but as I say, on a different basis from that on which they first took the case to the first tier tribunal. However, did they shoot themselves in the foot? Because if it was the case that the contribution first made to the trust properly counted as taxable earnings of the employee, then surely all this disguised remuneration rule doesn't apply anymore because it's already been taxed income. We're outside the scope of any arrangement connected with an employment. HMRC were clearly fearful that that argument was going to be run against them, because in 2018 they changed the rules again to make very clear that it didn't matter that you had a redirected earnings charge under the principle of Glasgow Rangers. The DR charges would still apply going forward. Now, and this is a point relevant to our debate in September, it seems to me that that particular change in 2018 was the most egregious and effectively retrospective change to the law, because it allowed the loan charge to bite going forward on loans made out of redirected earnings whenever those earnings were paid to the trustee, even if the revenue was otherwise out of time for assessing that contribution on the basis of Glasgow Rangers. Now, in parallel, the revenue had, since way before 2010, been encouraging, that may be the wrong word, but urging individuals and their employers to settle what the revenue believed were the tax charges arising on the making of these loans. They'd made their views known, ultimately through the spotlights, but previously in correspondence, and were very keen that people settle the earlier liabilities. They issued a formal scheme for settlement in April 2011, but this didn't contain any particular fiscal incentive to settle and was not taken up. They had subsequent initiatives to encourage people to settle. There was an eFIRBs resolution opportunity for those who structured their arrangements as eFIRBs. There was a further post-2015 settlement terms issued. These did offer a fiscal incentive because they specifically allowed relief for investment growth on earmarked funds. But of course, this didn't really apply to those who were the beneficiaries of loans. It did, and in my experience, I know of one situation in which the individual chose not to take a loan. He allowed the trustees to invest the monies. The monies multiplied. He earned many millions through investment returns, and by settling, he was able to do so on the basis that avoided any further DR charge on that investment growth, even when it was subsequently passed out of the trust. Then in November 2017, and because of the Glasgow Rangers victory and the principle it had established, yet further settlement terms were published. These were less generous, and in particular, there was no relief allowed for investment growth. And settlement has been permitted up until August this year even, provided that the circumstances were fully disclosed to the revenue by April of last year. Now, until the Glasgow Rangers case was finally decided, as I say, HMRC was doing everything in its power to persuade people to settle. The problem was that many advisors were saying to people, the revenues had not yet established the basis, the legal basis on which they were claiming settlement. And furthermore, the revenue were also claiming inheritance tax charges. An EBT is a discretionary trust. We're in the realms of inheritance tax. You can have charges when contributions are made in by way of transfers of value. You can have 10-yearly charges, and of course many of these schemes subsisted for more than 10 years. And even though loans were paid out, there was still value representing the entitlement to repayment of the loans in the trust. And if you reached a 10-year anniversary, there'd be a 10-year charge, which the revenue sought to recover from the individuals. And then there were exit charges. So if you settled with the revenue and there was going to be a release or writing off of the loan, there'd be a further exit charge to inheritance tax. These, coupled with the interest, late payment interest, amounted to sums which a lot of people just turned their backs on and decided not to settle. Furthermore, whilst we've been focusing on bankers' bonuses and schemes for owner-managed businesses, close companies, and these had extended around the country, at the same time, a practice had begun to grow of promoting these EBT loan arrangements to self-employed contractors, such as fairly modestly paid workers in IT, finance, oil and gas, capital projects, health, etc., on the basis that they could enhance their earnings, albeit by a little bit, by receiving their remuneration partly by way of national minimum wage and partly by way of a loan or a similar arrangement. And these were particularly attractive to those people who had personal service companies and were being chased for IR35, being treated as employees. There were many agencies, umbrella companies, many corporate clients engaging the services of such independent contractors, all of whom were being advised of how the use of loans in place of payments that would otherwise be taxable could substantially increase the levels of returns from an engagement where the cost was fixed by the ultimate client. The loan could be made variously by any of the client itself, the agency, an intermediary, or typically a trust established by the intermediary. And by 2011, HMRC's own estimate was that there were about 11,000 such individuals who'd entered into these arrangements. And that comprised both those who'd actively sought to take advantage of this, but also many thousands of individuals who had been required to participate in the arrangement as a condition of securing the work. Now, many of these arrangements arguably fell outside the scope of the main case of disguised remuneration because the loan was not in connection with an employment. It was in connection with a self-employed independent trade. And therefore, the revenue in 2017 added sections 23A, 23H, which I've mentioned, of ITOIA, which bring into account as a profit of the trade any benefit received by the trader or a connected person under an arrangement with a third party, the benefit being derived from a payment made for the services of the trader. Now, the revenue were very late in waking up to the extent to which EBT loan schemes have been adopted by or foisted upon these independent contractors. For the clients, the agents, the intermediaries, the rewards were substantial because, of course, there was a saving of national insurance and there was the opportunity for fees and commissions. And this meant that in practice, the worker typically was only marginally better off than if he or she had received the fees as under PAYE, as agency workers, or under IR35. But the arrangements continued to mushroom, and by 2019, it was estimated that 50,000 individuals had participated in these arrangements, being contractors in IT and these other fields, many of them having taken income in the form of loans each year for many years, all of which remained outstanding. Now, HMRC sought settlement by contractors in 2014-15, but as many were advised at that time, HMRC had no case on which to, or no basis on which to base a challenge. Unsurprisingly, there were very few takers. So, having got wind of what was going on in the market, we come to 2016. The government and HMRC had singularly failed to curb the promotion and use of contractors' loan schemes and to persuade those involved in all forms of EBT loan schemes to settle on the basis that what was received as loans was properly to be taxed as income, and if the loans were in connection with an employment subject to NICs and PAYE, their patience ran out. And so on 16th March 2016, the loan charge was first announced. And if a taxpayer, be it the employee, the independent contractor, or the employer, had not by August of this year settled the earlier liabilities, the loan charge applied on 5th April 2019. And at that point, I'm going to stop and hand over to Keith, who's going to guide us through the loan charge. Keith.
Thank you very much, David. And well, if I didn't know it before, I think we all know that Part 7A of ITPA is a ridiculously complicated piece of legislation, and it's imperative to look at it, but it's I think you need a health warning before looking at it, as well as a health warning about ignoring it. What I'm going to do in my session is actually to roll the clock back because I'm hoping. David, could you just nod if you can still hear me, because I've had connection. Yeah, perfect. Thank you. David has spent a fair bit of time talking about the disguised remuneration rules in Part 7A. It's important to remember they were enacted in the Finance Act of 2011 and effectively take effect from the 9th of December 2010, which was the date on which they were announced. But as David has already said, these arrangements had become quite common during what we now call the noughties. So there were a number of arrangements, particularly involving contractors, where loans had been made on the basis of many people's understanding of the law. Now, I think in many ways one can understand, as David has explained, if you think of the very simple situation which David described, in which an employer puts in the hands of a trustee funds which are then advanced as a loan, the employee isn't receiving salary, isn't receiving a bonus, but is receiving an employment-related loan on which the beneficial loan rules apply. So in that simplest form, I can certainly understand the attractions of these arrangements. As I said, they had become quite common, and some promoters disclosed them under DOTAS, and as David said, some didn't. For those who didn't disclose under DOTAS, they felt they didn't need to because they felt that the hallmarks were not satisfied, and the hallmarks of employment-related arrangements changed both in 2004 and in 2006. And those who did, well, they thought at the time there was nothing problematic about making disclosure because it effectively buys you some form of protection that HMRC know about these arrangements. HMRC, if they don't like it, they have to open an inquiry. And as we found out in the Charlton case in 2011-2012, the disclosure through DOTAS and putting a relevant DOTAS number on your tax return can often amount to full and adequate disclosure to protect you from discovery assessment. Anyway, the Revenue in some cases opened inquiries because they'd seen these forms, and what we now know in what's 2020 and in the late 2010s, the Revenue said, we took the view these schemes did not work. And it might be the case that they took the view that these schemes didn't work. But as David has explained, when they first expressed these views, and that was as late as 2009, they did so in the spotlights. And whilst there are a fair number of tax practitioners listening to this, who probably do from time to time look at the spotlights, how many members of Joe Public do you think will study the spotlights? I'd be surprised if anyone did. So the fact that the Revenue claim now to have had the view that these arrangements didn't work, in my view, is of little consequence because they did nothing to tell taxpayers that these arrangements didn't work. Remember, they'd opened inquiries in many cases. They had DOTAS notifications in cases. It wouldn't have taken a great deal of effort for them to say, we're opening an inquiry, by the way, we don't think these arrangements work. But they didn't, they just simply opened an inquiry, and the taxpayers heard nothing. And having heard nothing, the taxpayers think, well, wait a moment, there can't be anything untoward about these arrangements. So they stayed in for another year, and another year, and another year. So even if the Revenue thought they didn't work, they weren't exactly doing their job properly about protecting the Exchequer. Now, if the Revenue had said, we don't think these arrangements work, and they'll say, well, when the loan is advanced by the trustees, there's a tax liability arising. Well, if they had actually said that, then advisors would have said, well, that's not what the courts have said in the past, and quoting Semper and Dextra, for example. So even though the Revenue took the view that these arrangements didn't work, the arguments that they were running were not only defeated in the courts or tribunals, but the revenue didn't actually pursue them any further, suggesting they actually accepted that Dextra and Sempra were wrong. So even when we get to the Rangers case, 2011, I think 2013, and please forgive me if I get the years slightly wrong, but when the case went to the first tier tribunal and the upper tribunal, the revenue kept running the argument. These loans were advanced by the trustees. When the trustees make those advances, that's when a tax liability arises. And the majority in the first tier tribunal and the upper tribunal said, no, the revenue is wrong. So we now get to 2015, and the few faint protests from the revenue, these arrangements don't work, which were not exactly told to the whole world, but only to those who knew where to listen. The revenue, most you could say is, well, the revenue would say that, but they are consistently wrong, and the tribunal tribunals are confirming that they are wrong. Well, the Rangers case then went to the Court of Session, and at that stage, the revenue changed counsel. And the story that I have heard from a number of sources is that counsel said, and it seems fairly clear from the Court of Session opinion, counsel changed the argument. Rather than focusing on the advance of the loan from the trustee to the individual, the taxpayer, the revenue said, we're going to go to that earlier stage, the allocation of the funds to the trust. That's the PAYE moment. And that is the view which allowed the revenue to win in the Court of Session in 2015 and allowed them to win in the Supreme Court in 2017. So we have a situation where everything that the revenue had been saying over the previous 15 years, they weren't saying particularly loudly, but or weren't saying to enough people, but the view that the revenue were taking, these schemes do not work, was upheld, but for completely different reasons. So it is hardly surprising that taxpayers felt little compunction in accepting what the revenue was saying, because the revenue until then were running a very bad argument. Now, when I saw the Rangers decision in the Supreme Court, I read it, and I have to be completely frank. I was persuaded by it. It made an awful lot of sense to me. When you have an employer who agrees to pay an employee a sum of money, what typically happens is the employee doesn't actually get the money, it goes into the employee's bank account. So it effectively goes to a third party. If I, as an employee, say to my employer, don't put it into this bank account, put it into that bank account, the employer isn't usually bothered as to whether it's mine, or to use the phrase adopted by Lord Hodge in the Rangers case, my Aunt Agatha. Effectively, I'm contractually entitled to a sum of money. It doesn't really matter who gets paid that money. It is clearly my salary on which tax should be paid and PAY deducted at source. Now, it's quite possible that there are arrangements there, and this goes back to what I said right at the beginning of my presentation, that aren't quite as obvious as a diversion of salary to Aunt Agatha, where there is a genuine trust, a genuine allocation, and not effectively a diversion of salary. And in those cases, I would be more reluctant to say that Rangers applies. But in the typical scheme arrangement, and I will use that without being too pejorative, but in the typical arrangements that I have seen in the light of the loan charge, they are effectively diversion of salary. And I say Rangers is a full answer to the question as to when tax is payable and when tax is deductible. But the Rangers decision, both in the Court of Session and confirmed in the Supreme Court, gave rise to a huge fundamental problem for the revenue. As is quite obvious from the name Rangers, or the various incarnations of that name through its liquidation, Rangers was fighting a Regulation 8 determination issued by HMRC for failure to deduct PAYE as due. The primary destination for the revenue when they see that PAYE has not been deducted is not the employee whose income it is, but to the employer whose duty it is to pay the tax. So it's all very well looking at the early provisions in ITPA, which say the liability is the employee. When you get to the PAYE regulations, the PAYE regulations effectively displace liability and transfer the obligations on the employer. Now, leaving aside these kinds of arrangements, imagine any situation where an employer fails to deduct the right amount of tax. And use a simple example. The employer is paying the salary of £100 on which £20 tax should be deducted and paid over under PAYE to the revenue, but the employer pays £100 to the employee. Now, if the employer had done it correctly, the employee would be £100 down, £80 to the employee, £20 to the revenue. The employer has done it incorrectly. They've paid £100 to the employee. So the employee is in exactly the same situation as far as the cash is concerned that they would have been in had they operated PAYE correctly. The revenue is obviously £20 worse off. And one might think that the employee is £20 better off, or so no worse off, because they simply owe that money, that £20 to the revenue, either through self-assessment or under the P800 process. But within the PAYE regulations is a set of provisions that actually give the employee a credit for the PAYE that should have been deducted, even if it wasn't deducted. So whilst the employee ends up with £100 in his or her pocket, they are actually entitled to the £20 credit. So when the revenue comes knocking on the door saying, well, wait a minute, you've received £100 and not paid your £20, they can waive the regulation 185 or 188, saying, well, actually, I'm entitled to £20 credit. So you can't come to me. Yes, I'm £20 better off, but you can't come to me for the money, which is why the revenue has to go to the employer. Because if the revenue wants their £20, it's the employer whose duty it was to deduct the tax in the first place, to whom the revenue should turn. So the employer, if the revenue comes along under Regulation 80, ends up being £20 worse off. So rather than just £100 down, they're £120 down. £100 they expected, but the £20 is extra. Now, there is also case law, common law provisions that say that actually the employer can now turn to the employee and say, well, that £20 we had to go over to the revenue, we can collect from you under the principles of restitution. So effectively, everyone is in the right position if the employee can be found and is asked for that £20 from the employer. Now, there are situations in which the revenue can not go to doesn't need to go to the employer and can go directly to the employee, but they are quite restricted. So on that basis, the revenue was quite right to go for rangers and would have been wrong in many cases to go to the employee. But this is where the revenue found that their change of argument, I don't mean to use a football analogy deliberately, but at least it was a partial own goal. Because having established the principle that the original payment into the trust was the PAYE-able event, what the Rangers' decision has effectively confirmed is that it was Rangers and not the trustees who are liable for the tax. If the Rangers were liable for the tax when the money went into the trust, then it's Rangers, the employer, who should be called upon to pay that tax. And equally, the employees would have a credit. So come along 2015, Court of Assession decision, the revenue realised they were in somewhat of a pickle. Yes, they had won the Rangers case, at least at the Court of Session stage, but confirmed in 2017. But did they have the opportunity to go to the employers for the money? And here they were faced with a couple of problems. In many cases, they had gone to the employers, but the employers by this stage had been wound up because the revenue had taken so long to go after them. Everything was put on hold pending Rangers. But for other employers whom the revenue hadn't gone after, the revenue were now too late to go after in many years because of the normal 4-year, 6-year, and 20-year time limits that apply. Now, 20 years, you can go for 20 years if the revenue can show that you've acted in a deliberate fashion as to underpay your tax. Given the history, I don't think the revenue could seriously suggest that they had assessing rights after 20 years. I do say that I was in a meeting with the minister and some senior revenue officials discussing the loan charge. This must have been losing track of the time, 18 months ago. And the revenue said, oh, yes, we feel that we can go down the 20-year route. Well, I don't believe them, but they would say that, wouldn't they? Even 6 years, they have to show carelessness. And given the strength of advice given and the history of the cases prior to Court of Session's decision, I think even the revenue would have difficulty showing carelessness in many cases. So they were left with a 4-year assessing time limit. And whilst that's the assessing time limit for discovery assessments, it's also the same, it's applied for the purpose of Regulation 80. So the revenue realised in 2015 that they were in a problem because, yes, they'd established the liability, but they had no one they could get the money from. They couldn't go to the employees because the employees, because of the restrictions on the right to go after the employee, and there weren't any employers they could go after either. So this was going to look rather embarrassing. So someone behind the scenes had to work very carefully to find out a way of transferring this liability from the employer, who is now untouchable, to the employee who was at least reachable, if not currently touchable. And this is how the loan charge arose. It was a device, an extremely complex device, in order to allow employees who were previously entitled to a credit and could, subject to the way latest case law has evolved to an extent, entitled to this credit, and the revenue certainly believed they were entitled to this credit. How do we actually effectively negate the credit? So what they've done is they have created ex nihilo, if you excuse the Latin expression, but out of nothing, they have created a liability so that the employee pays the tax. Now, they couldn't simply say, we are going to rewrite history and say that the credit to which you were entitled, you are now going to have denied to you. That would have been the honest and simplest thing to do, but the revenue knew they couldn't do that because retroactive legislation just would not be acceptable, even in this situation, notwithstanding the Dawn Pomeroyal statement in 2004. So what they did was said, well, we don't like these loans. We don't think they're genuine loans. Yes, they're genuine loans when it comes to inheritance tax, but they're not genuine loans when it comes to income tax. We're going to pick a date a few years ahead, and it was chosen at 5th of April 2019, so roughly 3 years after the budget announcement, and say any loans that are still outstanding, we are going to treat as if you had effectively been paid the amount outstanding as salary. That's not quite how it ended up, but effectively, the amount outstanding on the 5th of April 2019 would now be treated as a sum on which tax should be paid. Now we'll come into the some of the consequences of that. People who had loans over a number of years would then find themselves doubling, trebling, quadrupling, or multiplying even further the amount of taxable income in one tax year, which then has adverse effects on tax rates and also marginal rates when it comes to the loss of personal allowance. So there was an unfair lumping together of income, causing a disproportionate tax charge coming on. Now, this situation was clearly a very unattractive proposition. So The budget 2016 announced a consultation, and consultation responses were received. Now, the CIOT expressed concern about what was effectively retrospective legislation. The ICAW was even more damning in its criticism, saying that this is effectively unacceptable retrospective taxation, because what you are doing is effectively, even if you are creating this tax charge in respect of a future event, what you're trying to do is put pressure on taxpayers to settle a liability that they didn't actually owe, because the revenue had still got these inquiries open. They'd not done anything for 10 years, but they said, well, wait a moment, we want our tax in respect of these early years. If you pay in respect of 2009, 2010, or whichever year it was, in some cases 2004, 2005, then you won't have to pay the loan charge. So as long as you pay us this sum in respect of those old years, we will let you off the loan charge. But ultimately, that's saying, if you pay us a sum that you don't owe, then you won't have to pay us another sum. In other words, the revenue were just simply trying to put pressure on taxpayers to pay money they didn't owe. Anyway, going back to the consultation responses, taxpayers got wise to what the revenue were planning, and they also responded, and they said, this is not fair. This is you effectively charging us on sums that we did not think that had to be paid, and you're effectively charging us in respect of prior events. Now, what the revenue did was, when they summarised the responses for ministers, they said they lumped together the CIOT and the ICAW's response and those of the contractors who also responded, and they said, well, we've had a large number of objections, but most of them, I think it was 90%, come from adversely affected parties. In other words, the contractors almost shot themselves in the foot by saying that they didn't like it because the revenue could use the fact that they were self-interested in the legislation or in the proposals in order to dilute the impact of two of the largest and most respected professional bodies' criticisms of the proposals. So the fact that these professional bodies said, we don't think you should be going down the retrospective route, which is what you're doing, was diluted by the fact that there were an awful lot of objections by people who had self-interest. So the revenue's response document shows a rather deliberate attempt to dilute the retrospection aspects of the legislation. The revenue then also highlighted the fact that the CIOT and the ICAW supported the idea of tackling avoidance schemes such as this. So the revenue were able to cite the ICAW and CIOT when it suited them, but effectively span their way through the consultation process. Now, part of the rationale of the loan charge was this was to put an end to all such schemes. Well, it's quite clear, if you actually read the legislation, that it doesn't put paid to all such schemes, because the loan charge applies only in respect of loans outstanding on the 5th of April 2019. If you enter into a scheme, let's say on the 6th of April 2019 or later, then you can see that actually the loan charge does not apply at all. So the loan charge is not in any way, and it's a complete misrepresentation for anyone to say that it is the government or the legislation's way of stopping these schemes from operating. It's effectively an endorsement that you can get away with it if you try again after the 5th of April 2019. And David and I have both heard we've heard recordings of people selling these schemes this month or last month. People are still peddling these kinds of schemes, and just to show that the loan charge does not apply to them. And they're now being, I wouldn't say devious, I think I would go as far as saying almost dishonest. They're saying, well, as long as we don't call part of your payment salary, then we don't have to pay PAY on it. Now, that would be the most amazing form of tax avoidance. Just ask your employer to say, keep paying me for what I do, but just don't call it salary. That is the nature of the schemes as they are currently being touted. And one scheme saying, well, we can make an investment payment to you, which we can ask back. Now, we only say we're asking for it back because it looks better for the revenue. In other words, it's a sham. But more importantly, it's not a loan because we're calling it an investment. The idea that you can change the legal nature of any transaction just by labeling it in a different way was long disposed of in the 1980s. The case of Street and Mountford. Don't worry about that. It's not a tax case, but it is worth bearing in mind. So these schemes are still being peddled and the loan charge will not affect them. Anyway, the consultation process, I would say, was pretty much a sham. The government was minded to carry on enacting this legislation. It was delayed because of general elections in 2017. Gosh, it's really 6 months since we haven't had a general election. Gosh, what's happening to the world? Anyway, 2017, there was a general election, so it was delayed to the Finance Number 2 Act 2017. And the legislation itself is complicated. I will try to summarize its main effects, but I will not attempt to go through the details. But the main impact of the legislation is to say that if you have an amount outstanding on the 5th of April 2019, that, and in its current form, it relates to a loan advanced on or after the 6th of April 1999, so it covers a 20-year period. Rather than saying that is a taxable event, that then is shoehorned into the disguised remuneration rules, which David has explained, and it's defined as a relevant step. So you've got one complicated bit of legislation effectively shoehorned into another complicated bit of legislation. For those reasons, I probably suggest that you buy David's book because it's the only way you'll be able to make any sense of these two pieces of code. But the other part of the loan charge legislation, which is worth bearing in mind, is the fact that there was a notification requirement, which has since been extended. And I think that the only reason for that is because the revenue has got no idea who has actually participated in these arrangements, and they effectively need taxpayers to put their heads above the parapet so the revenue know who they can then come after if they haven't actually complied with the code. So there's an obligation to say, yes, come for me for the loan charge in due course. So bear in mind, not just the fact that you have to pay the tax, but you have to disclose yourself. Now, the legislation is, you can call it retrospective, you can call it retroactive. Different people use those terms in different ways, and the revenue is allowing the uncertainty as to the use of those words to effectively deflect any criticism of the legislation. The legislation is undoubtedly taxing people in respect of a future event, but based upon past events. So whether you call that retrospective or retroactive, I don't really care, but it is effectively charging you in the future in respect of what you did in the past. But it's also more serious than that, because it was effectively used as a pressure lever to force you to settle a liability in respect of a past event, which you did not actually owe. Now, there was controversy. MPs were being lobbied hard about it because most MPs are pretty decent individuals. It doesn't matter which side of the House they sit on. They do not like the idea of retrospective legislation. And they felt that this was legislation that was just not fair. Compounded with the fact that the revenue knew about this and did very little about it. Now, I have no idea whether promoters really said that these arrangements were HMRC endorsed. I doubt that HMRC actually said that. Well, I know that HMRC would never have said it. I'm not sure whether people actually said it in those terms. But when you have DOTIS disclosure, you certainly have the revenue aware. And if you have the revenue doing nothing about it for 10 years, in the meantime, it's not surprising that many people felt that the revenue had no objections to it. So with all of this, there was a large number of MPs who were concerned about this legislation. And that forced a sort of little mini revolt at the report stage of the Finance Bill 2019, which caused an amendment to be made, and the revenue were forced to enter into a review of the legislation. However, that review was effectively given to the Treasury and the Revenue to mark their own homework, and given all the skullduggery that had taken place in getting the legislation enacted in the first place, i.e. a very well-spun consultation document, and what I've also heard, giving the legislation late to avoid any real serious challenges to the legislation in the committee stage. I don't know whether that's true, but certainly what has been rumoured. Anyway, the Treasury said, we think this legislation is completely fair. Well, people were not satisfied with that. As I said, it's like marking one's own homework. So the calls for an independent inquiry grew, and Boris Johnson, then as a candidate for leader of the Conservative Party, said, well, if I'm elected, I think I'll have a review. This does seem terribly unfair stuff, etc., etc., etc. And in the end, in September 2019, a review was announced. Now, I personally would like to believe that Sir Amias Morse, who was asked to conduct the review, conducted this with every intention of doing so fairly and independently. He accepted that the retrospection going back to 1999 was totally unjustifiable, notwithstanding the fact that the Revenue and Treasury only 9 months earlier had reached the conclusion that it was perfectly fair. He, however, decided that in 2000, that the announcement of the disguised remuneration rules in December 2010 was the clear marker that these schemes were not acceptable, and therefore people should have known that these schemes were not to be followed, and therefore he thought it was the compromise he went for was going back to allowed the loan charge to apply for loans advanced on or after the 9th of December 2010. And the official line was, it was perfectly clear that these schemes did not work then. I think it's perfectly clear that these schemes would cease to work from then. But as David pointed out, and it seems now like an hour and a half ago, what the disguised remuneration rules in Finance Act 2011 did was they made these schemes ineffective so far as employments were concerned. They did nothing for those who were self-employed. Now, there are many workers out there for whom it is clear that they are employees or self-employed, and therefore you can't really say you can't justifiably sort of jump one side of the line or the other. But a lot of the people who've been sold these arrangements were consultants. And consultants are, just by the nature of their work, providing their professional services on short-term contracts, are very much on that boundary between employment and self-employment. And if you just look at 2 IR35 cases recently, there's the Mr. Alcott case, RALC Consulting, and a Northern Lights case. And those 2 cases have come up with different conclusions. Mr. Alcott was found not to be a pseudo-employee and therefore outside IR35. The worker in Northern Lights was found to be within IR35, although I actually think that decision was flawed. But it's not hard for a contractor to suddenly become a genuine, or at least perceive themselves to be a genuine self-employed individual. So all you had to do, and this is what the promoters did, from the announcement in 2010, said, okay, we'll change the contractual arrangements and make you self-employed. Therefore, the disguised remuneration rules do not apply to you. And therefore, to say it was clear that these schemes did not work from the announcement in 2010 doesn't really explain why it's fair for contractors who then became truly self-employed from 2010 onwards. They knew that they were under the impression that the disguised remuneration rules wouldn't apply to them. Therefore, the schemes would work. And it was only in 2017 when the self-employed were brought into the DR code, and even so, that was only to enable the loan charge provisions to extend to the self-employed. So I do think Sir Amias Morse was mistaken when he reached the conclusion that a clear marker was set in the ground in 2010. It was clear that the revenue was prepared to stop these schemes for employees, but it was equally clear that the revenue were not interested, or did not appear to be interested, in pursuing the self-employed. Anyway, so Amias has recommended a number of suggestions, some of which have been implemented or will be implemented in the current finance bill. Most importantly, the one-off tax hit in 2018-19 is going to be spread over 3 years, and there'll be other sort of minor modifications to the rules. But I'm still of the view that whilst Amias was probably aiming to come up with an independent view, I do think he was mistaken, and therefore he was right to object to retrospection, but he was wrong, in my view, to say that retrospection could be justified back to 2010. Now, I think not only have I come to the end of my time slot, but I've probably come to the time when it's appropriate to ask for some questions. So I don't know whether, Marla, you're going to take questions, or whether you want David and me just to sort of look through the chat and sort of just argue who's going to speak on which point. I have silence, which suggests that
You're on mute.
I've gone on mute, have I?
No, Marla is.
Can you guys hear me?
Perfectly.
You can.
Yeah,
okay.
now.
I said I was using my phone as to listen to you and a video to see you. Very complicated. Right. Thank you for that. It was very in-depth and complex background to the loan charge. I think it's understandable, not understandable, I should say, that if HMRC have issued such complex legislation to issue the loan charge, how they could expect taxpayers to understand the schemes were inadmissible, should we say, is beyond me at this point. What we're to do at this point is we'll take questions. I suggest, because there's so many of us, that we put them in the chat, and we can go through them one by one. So Sabir asked, what are the restrictions of PAYE Regulation 72?
And I can answer that one because I've got 72 in front of me. The revenue can, in order to go down the Reg 72 route, i.e. to decide that the employer can be excluded and you can go straight to the employee, the revenue has to show one of two conditions. Condition A is the employer took reasonable care to comply with the regulations, and that failure to deduct the excess was due to an error made in good faith. So the employer has got to show that they did things completely properly, and it was just an unfortunate mistake. Now, I think there's an argument to say that actually 72 can be applied in many cases, but the revenue is quite shy to go down that route. The harder one for the revenue is that is condition B, that they've got to show that the employee received the payments knowing that the employer willfully failed to deduct the amount of tax which should have been deducted from those payments. Now, in layperson speak, that is a situation where the employer says, I'm going to pay you cash in hand so I don't have to pay tax. And you don't have to pay tax. It's pretty extreme stuff. So, as I said, condition A can often apply, but for some reason the revenue seem to be reluctant to go down that route. Now, Regulation 81, well, that leaves, there are other situations which the revenue can transfer liability, but that's getting even more complicated because it's going down route 72F, which was introduced about 13 years ago. So this leaves the first port of call to be the employer. But as David said, the typical situation is that if the employer hasn't paid within 30 days, then the revenue can go to the employee. But unless it's a notional payment, which cash normally isn't, then they have to satisfy what again is known as condition A, and it's the willful failure to deduct. Now, is it me who's gone offline? Can someone wave to say they can hear me?
I can still hear you.
Wait, that's right.
Yes.
So I just got a warning to say that bandwidth was low, so I was getting concerned. So the PAYE regulations are there to protect the employee generally. But we've now got a series of case law that says the revenue can bypass these regulations and use a provision in section 6847A. And I'm sorry to get all techie, and I think the tribunals have gone completely down the wrong route in this. But in 2003, in the Finance Act 2003, ITPA was amended to allow the revenue to disapply the PAYE regulations. I've got a copy of 684 more or less in front of me. And the situation where this was enacted, and I was actually working for the revenue shortly before this, and I was working on the PAYE regulations through the rewrite process. And one of the things you do when you're rewriting secondary legislation is to make sure that you've got the virus, the legal power to provide for the provisions in secondary legislation, and you've got to provide that power in primary legislation. So one of the things that the revenue were keen to do was to ensure that the primary legislation in Finance Act 2003 allowed certain things in the secondary legislation, the regulations which were coming out later that year, to be lawful. And the situation they were envisaging was a situation where, for example, the Catholic Church, priests are typically officers or employees of the Catholic Church, but the Catholic Church does not typically pay them, that it's the parishioners who pay them. And if you follow the PAYE legislation literally, it's every time you put money into the collection church, your collection tin, you're supposed to operate PAYE, your own scheme in respect of your priest. Now that is slightly inappropriate, or at least unfeasible. So what section 6847A provides is that the revenue can disapply the PAYE regulations if they are satisfied that it is unnecessary or inappropriate. And therefore, Catholic churches or the priests are no longer subject to PAYE, and they effectively have to self-assess their employed earnings in the same way as the self-employed individuals do. So that's what 6847A was there for. But the revenue, realizing the potency of these regulations and the safeguards in the regulations for employees, suddenly decided that they would use 6847A, make determinations under 6847A in 2016, 2017, 2018, so as to say that the PAYE obligations that the employer should have had and failed to deal with are being retrospectively suspended, so that there is no, effectively, you lose the credit because you're entitled to the credit when there's been a PAYE failure. If the revenue retrospectively say there is no PAYE failure, then there's no credit, and therefore you have to pay the tax. Now, I fundamentally disagree with the way the tribunals have gone, but I believe that 6847A applies only to a prospective obligation rather than a past obligation. But I don't know whether the Hoey case is still going ahead, but I'm hoping that they are going to address that in due course. That's a very long answer to one question. And David,
can I just add to that in my experience, Regulation 72 is used where the situation is that the employer hasn't paid the right amount of PAYE, whereas Regulation 80 is where they haven't paid any at all. And it's Regulation 80 and 81 that's been amended to take account of DR and the loan charge, and to effectively allow the revenue to go straight to the employee without the safeguards. So I think it's Regulation 80 that the revenue is envisaging taking action under, and also Regulation 8 of the Social Security legislation, although there's no equivalent, they can't go against the employee or the employer's 13.8% NICs.
Okay.
Thank you both. Just asking people who are asking the questions, can we try and keep them general rather than personal, just in the interest of time, and also just for everyone who's listening. If you do have personal questions, you can feel free to contact me or Thomas or any of the speakers, and we'll put our contact details on the chat a bit later on. So someone has asked, is there a threshold amount that HMRC won't go after someone? Do they have a de minimis?
Not that I'm aware of.
I'm not aware of whether Thomas has any views on that. I don't know whether he can chip in. Because of your WTT's experience.
Yeah, I mean, I think that the context there was generally in the context of MARD. When I read the question, it looked to me like it was someone that was abroad and was more interested in what the de minimis of HMRC asking another competent authority to chase the payment on their behalf. I think the answer is just as Keith and David has said, no, it's the simple answer, not I'm aware of.
Yeah, and I would agree with that one as well.
In relation to the requirement to disclose, I was told it was £5, but there we go.
So this might be a moot point now, but should the loan charge have gone to the PBL, the Law Office and PBL Committee for permission, as because it's retrospective? This is according to the Parliament Act legislation guide. Do you know anything about that? Should it have?
Keith, that's one for you.
Thank you. I owe you one then. As I said before, people have different views as to what retrospection and retroactive are. It's certainly something which I think should have been looked at very carefully. The revenue have been hoodwinking ministers left, right and centre about this legislation. And I think any integrity that they did have and any perception of integrity they had has been severely diminished by their conduct in this field. And there's an awful lot that will be written, no doubt, in doctoral theses in years to come. I think that's a good question to raise for doctoral theses. They should never have got away with this legislation. Go back to what I said right at the beginning. The revenue knew about this right at the beginning, and they failed to take action in time. It's their own backsides they've been covering up. And the one thing they have failed to mention is their own culpability in the entire fiasco. So if tax has gone unpaid because people were in these schemes for a long time, it is the revenue's fault only. I'm not saying that I approve of the way they were marketed, but equally I'd say, given the way the revenue were saying they would challenge them, I can understand why people thought these schemes worked. Yes, there should have been possibly greater warning signs. I haven't seen the original advice given, but the revenue will do everything to avoid this being properly scrutinised. And I think that is the most unfortunate part of this whole episode.
I just get back to the point I made earlier that what we were expecting was something along the lines of Section 455, the loans to participators charge. It would have been simple, straightforward, and readily understandable. And what I was told was that it was a ministerial decision that it be structured as a tax charge on the employee, not on the employer.
Even though there was a PAYE liability.
Yes.
So I should probably mention this one before. Someone from HMRC did register for the webinar. I don't know whether they're actually on the webinar, so FYI. I don't think they are, but just in case.
I have no problem saying what I've said. I've said it in a million sources, a million different places, slight exaggeration, but this is somewhere where I'm more than happy to say the revenue do a hard job in difficult circumstances and often do it well. But this is one where they have acted with complete disingenuity, and I'm not ashamed to say that.
Fair enough. I think we appreciate the honesty. So someone has asked whether the loan charge legislation therefore does not apply to direct employer-employee loans, i.e. no third party, and I'm assuming that would just be taxed under normal employee benefits.
Yeah, that's right. If you've got a situation where it's a loan made by an employer to an employee and there's no involvement of a third party, that is completely outside the scope because you don't come through the Section 554A gateway. And if you don't come through the gateway, the loan charge doesn't apply.
Yeah. Okay. With all open inquiries, this one I think is probably more about discovery assessments and staleness, but with all open inquiries, there have been some determination of stale inquiries. What are the legalities around who's determined as stale? Keith,
that's a question for me. Since I am the person who introduced the concept of staleness, which will either be vindicated or completely rubbished by the Supreme Court next year, it's got to be remembered that was said in the context of discovery assessments. And in order to get that argument any traction, I had to rely upon the meaning of the word discover. Therefore, whilst there has been a lot of suggestion that staleness can be used to kill an inquiry, I personally, it's not an argument I have raised so far. I think it would be one which would be difficult to challenge on that basis because staleness, as it currently stands, turns on the word discovery. The Supreme Court might turn around and say, well, actually, staleness doesn't turn on discovery, but it's just a concept of fairness. And you can actually strike down, if you've had an inquiry which has gone on for 10 years and nothing happened in that 10 years, then to have a liability imposed upon you out of the blue, almost, after such a long time, was so unfair that you can actually get it set aside. So there are some procedural challenges one could make, but staleness, I think, is solely related to discovery at the moment. But watch this space and hope.
Sorry, I was just going to say, it's probably worth saying there, Keith, that the concept of staleness, and you will absolutely correct me if I'm wrong, it is not about the time of inactivity between raising the assessment and the revenue taking any following action. It's the revenue officer discovering that there's an under-assessment of tax and then taking action to raise the assessment.
Absolutely. And it's also worth bearing in mind that even if there was a long interval, it is possible through action by the tax officer to keep it fresh. They don't have to act immediately. It turns on the facts of individual cases.
Just David and Keith and Tom, are you pushed for time or are you around?
No, I'm fine.
We're locked down, not going anywhere.
So I have places to go, people to see. No, fine, then we'll just carry on. Right. If the retrospective aspect of the discovery type one, but if the retrospective aspect of the loan charge is removed, what is your assessment, your general assessment on open inquiries, and does HMRC have a strong position?
I can take that, unless David wants to chip in. My personal view is, and the view I have taken, at least in the few cases I'm running at the moment, is we've effectively conceded ranges. We said, yep, it's employment income from the word go, Rangers tells us that, however, there's the credit. And the argument at the moment is whether that credit can be removed through the exercise of section 6847A. There's also the argument as to whether that credit is something you can run in an appeal in the first tier tribunal or only on collection procedures in the county court. Now, ultimately, it doesn't really matter. As long as the credit is there, then it doesn't matter at what stage you use it. It makes a lot more sense for it to be dealt with at the first tier tribunal stage, because you've got a expert tax panel who are able to understand the nuances of this. But ultimately, if, as the case law is suggesting, the first tier tribunal does not have jurisdiction to hear it, then a county court judge saying can't simply go, this is, and those of you who've been to county court proceedings, this, when they see tax, they go, gosh, this is far too difficult for me, go away. A county court judge will have to grapple with it, although it could possibly be promoted to a high court judge or circuit judge, depending on the case. So my personal view is that the best line of argument is the availability of the credit, which is why the revenue are so desperate to get rid of that POA credit.
Yeah. Okay. This one, I think, some people for a bit of comfort. Is there any legislation under which pre-2010 can be taxed?
Sorry, I didn't hear you, cut out at the crucial moment. What was the date?
2010.
Well,
There's an open
the
inquiry.
idea is that following the Glasgow Rangers principle, there is a liability pre-2010, but the problem is, in many cases, the revenue can't collect it, can't recover it. But so far as the loan charge is concerned, if you pay tax on the loan charge and you then subsequently write off the loan or have the trustees write off the loan, that triggers a further charge. Now, you may get credit that reduces the further charge to zero, but there are circumstances in which, by reason of the double taxation provision in those nastily labeled section 554Z, 11B and C, you can get a situation in which tax which is available for credit against a subsequent charge is actually swallowed up because it is first credited against an earlier charge, notwithstanding that the revenue cannot recover the earlier charge. And therefore, you end up overall, over time, incurring much higher tax charges than before. So the fact that the revenue cannot simply recover an earlier charge doesn't mean that it falls out of the picture altogether.
Okay, that makes sense. Probably not as comforting as the person wanted. Is it the case that HMRC's analysis that IHT is payable is agreed, or is there a sense that someone's going to challenge it, or how is that going?
No, well, I'm certainly challenging it. I had a meeting about 3 or 4 months ago before lockdown in relation to a claim for IHT, where we are saying it relates to an EFIRBs and a payment was made out of the EFIRBs to wind up the trust. The problem is that the taxpayer had previously settled earlier liabilities, and under the terms of settlement, it had been agreed that there were no further there'd be no further liability to income tax going forward. Now, when the trust was wound out, the payment was made out, revenue came along and said, aha, we want inheritance tax because there is an exit charge. And we say no, because if you look at section 70, subsection 3 of the Inheritance Tax Act, there is no exit charge, where what is what gives rise to the exit charge is income for the purposes of the Income Tax Act. And we say that if you look at section, I think it's 393, is it, of ITPA, that a payment out of an EFIRBs triggers a liability to income tax. The fact that the revenue have previously agreed under a contractual settlement that they're not going to collect the tax is neither here nor there, and therefore there's no charge to inheritance tax. Now, the revenue have gone away and said no, they don't accept that unless there's an actual charge to income tax at the time something is paid out. They won't accept that that exemption applies. Now, that's just one aspect of inheritance tax. So far as the 10-yearly charges are concerned, I think they're on much stronger ground. You do have a discretionary trust. I know the charges are relatively modest, maximum 6% rate on the value in the trust. Of course, the value of what's in the trust includes the benefit of the entitlement to repayment of the loan. So the amount on which the charge is raised can be fairly substantial. But there, I think they are on stronger ground. Having said that, I would have said that if the revenues approach were to be that all these loans were shams, they were in reality, it should have been taxed as income at the time the loan was made, then inheritance tax has no part to play in the arrangements whatsoever. But this argument has still to run. There was no mention of inheritance tax in the Morse report, Morse review. There's been no word from the revenue as to whether they're going to change their stance. So as we stand, if you're in settlement negotiations, in my experience, they are still calling for settlement of inheritance tax as a condition of accepting settlement overall. There's also an outstanding question of the extent to which the nil rate band applies to trusts. The revenue seem to be taking a rather odd view that it applies to certain types of trust and not others, and it's unclear on what basis. So the short answer to the question is there's no resolution of that. It's still outstanding.
Okay. Thank you for that. Right, this one, there are two questions that are quite similar, which have now disappeared. The draft legislation far exceeds the intent of Sir Amias's recommendations in regard to disclosure and taking action. Do you think changes are likely to the draft bill as scrutiny in committee stages seems insignificant? That's one question. And then the other one is, what is your view on the most likely basis for amendments at report stage?
I think the problem is Parliament isn't functioning properly at the moment, and I suspect this will slip through without scrutiny. I've not seen reports of committee debates. I don't think there've been any committee scrutiny yet, has there, Keith?
I think the loan charge legislation went through committee, but with a warning that it's going to be revisited at report stage.
Right.
But so clearly there is some move to have a challenge, but I don't know the nature of it. And I think you're right, Parliament is not operating properly generally at the moment, which is
essentially all party parliamentary groups report that was published in March.
I've lost track as to all these reports.
Well, there was a second report published in March in response to the Morse review.
Yes, the APPG is there are a number of I can tell you there are a number of MPs who are unhappy. And what I did also learn, and this is possibly why it's being dealt with at the report stage, is that the Finance Bill Select Committee, i.e. the 20 or so people on either side who actually debate it, they are always packed with party loyalists. So the only way of actually getting any changes is by relying upon backbenchers who are unhappy with the provisions actually to rebel against their government. And to get into the committee, if there was any hint of a potential rebellion, they wouldn't be selected. So when there's something contentious, the select committee process is just completely inapplicable. But perhaps the APPG feels comfortable that they will get enough mileage and backbench support at the report stage. I don't know, they did a year and a half ago. But to predict anything in politics at this moment is probably folly.
As a general rule, you always have to identify a member of the committee who has sufficient knowledge and detailed knowledge of the matter and can speak intelligibly, or can at least, and is willing to speak to a brief that is provided to them. History shows that that's sometimes quite a challenge.
So then I suppose that brings us on to the next question, which was, should people wait for the finance bill to be published before settling, or just want to HMRC and carry on with the process? What would be your advice on that stage?
Well, I think that is entirely fact dependent, and you have to go through the spreadsheets and do the figures to decide whether and on what basis it might be worth settling. And very often, by the time you've totted up late payment interest and all the other things, it comes to a large amount. But if you settle, the loan charge doesn't apply, and the amount on which you settle can therefore be used under section 554Z5 to reduce the amount of any subsequent DR charge that might arise if, for example, the loan is then released and written off. If you don't settle, then, as I say, the effect of the alternative double taxation provisions will normally be that you'll end up being much worse off.
From a practical point of view, most people have at the moment a settlement offer from the Revenue. Now, you're not committed to that settlement until you sign what's called a letter of offer, and you'll know a letter of offer because it's usually headed letter of offer, and it looks very much like a contract. I think that from a practical point of view, there's no harm in carrying on the settlement process, because by the time you do get that letter of offer, you'll know what has been passed in royal assent in the finance bill, and you won't miss the cut-off of the 30th of September, which the Revenue put on all settlements.
Yeah.
There's another subtle point here, which is that if it's a settlement by the employer, then because it's a contractual settlement, I don't think that you get a section 222 charge if the employee fails to make good, because what you pay under a contractual settlement is not tax.
I think the Revenue would dispute that, David, although I tend to agree with you.
Does Keith have a view on that?
He's not going to express one.
Is he still there is the question. Right, so let's carry on. The answer to that question was basically it's a case-by-case basis. There's no harm trying to get a letter of offer, but you're not contractually bound by it unless you sign it, basically. So you can hold on to it until the finance bill is over if you want. Can the Revenue issue APNs, so accelerated payment notices, for open pre-December 2010 loans? And then also on APNs, if they raise APNs for loans disclosed under DOTAS, a valid reason, is there a formal inquiry on the loans in place?
Do you want me to take that one?
Happily.
Go on.
So, I mean, a lot of is being hung on this 10th of December date. Don't forget that's purely in relation to the loan charge. If you've got open inquiries, then APNs can be issued if they meet the criteria. In the main, that's the scheme was DOTAS registered, or there's been a follower notice issued, and you have an open dispute with the Revenue, whether that's an inquiry or a discovery assessment. The loan charge and administrative review has not changed that in the slightest. The next bit is if you have an APN, then you have an inquiry or an open assessment. So the question there about does that constitute an inquiry, you almost certainly already have one if you have an APN. So I think you need to probably have a check back through your paperwork and see what the position is there.
There's also a technical point that if you pay under an APN, you don't get credit under section 554Z5. It's not treated as a payment of tax on an earlier charge. It's treated as a payment on account, which doesn't count towards that credit. And so you can find yourself believing that if the loan is subsequently written off, you've got the benefit of Section 554Z5 when in fact you don't. And I know of this point because I sat through one of the judicial review challenges to the loan charge, and the revenue denied that that was the effect of Section 5545. But if you look at subsection 11, I think it's perfectly clear. They seem not to understand their own legislation.
Not for the first time. Can I just, if I can just take one final practical point about APNs and existing inquiries. My understanding is that the team issuing APNs will not necessarily be working from a list of open inquiries, but working from a list of known participants. Therefore, there are possible chances that the inquiries that the APN team assume have been opened haven't been opened. Plus, it's possible that the inquiry notice was sent to the wrong address, not received, sent too late, particularly if you were a voluntary tax, putting in a voluntary tax return and you put it in late. So there are all sorts of arguments to say, actually, the inquiry itself is not valid. Now, it's not going to help everyone, but don't just assume that because you've received something that is predicated on an inquiry having been opened, that the inquiry is actually validly opened.
Yeah, so always need to check the procedural points before entering into any sort of discussions with HMRC to make sure they haven't slipped up somewhere.
But I think, sorry, Mala, carry on.
No, go on, I was going to go on to a new question for finish.
I think the important thing to bear in mind, and the point has been made, but it's people should never overlook it. The loan charge is a device to effectively put pressure on taxpayers to settle. There is still, for those with open inquiries and a few cases with discovery assessments, there is still the revenue having the right to look back at the original advance to the trustees as a taxable amount on which you will be paying tax, subject to your right to the credit. The loan charge is effectively just one extra bit of pressure that for pre-2010 cases has been removed, but it doesn't actually end the argument as far as the revenue is concerned in most cases.
But surely, even in pre-2010 cases, if unusually the revenue still has an open inquiry or an assessment and can recover that tax, it's still open to it to do so.
Absolutely, that's the point. Yeah. That is precisely the point. And it's not exceptional. There are an awful lot of inquiries which were opened and were just left open. Yes. And you and I know, and most people listening, that an inquiry can't close due to a fluxion of time. But to the layperson, they can assume that a letter written in 2006, I've got a query, I'm opening inquiry into your tax return, but I'm not asking you any questions at the moment. By 2016, it's not unreasonable to think that they might have decided that's no longer a valid inquiry.
And the other thing is I've recently been approached by a lot of insolvency practitioners who are dealing with companies who are being pushed to go insolvent because of outstanding taxes, some of which are due to the loan charge and other avoidance schemes. Now, in one of these cases, the loans were repaid before April 19th, so the director wasn't actually caught by the charge, and the revenue for some reason were unaware of this, and they were still pushing for the insolvency. So it's just other things to keep in mind, isn't it? Just double check everything the revenue are saying to make sure that it is in fact correct, just in case. Right, next question. Some loans have been sold on or transferred to another party, and that other party are recalling the loans. The implication of that is what?
Well, I think
the trust law implications to that for a start. I mean, if this is a situation where the trustee has effectively passed over the entitlement to repayment of the loan, then you've got to look carefully at whether the trustee's been acting in accordance with its duties, And certainly in Jersey, Guernsey, I have suggested that people ought to go to the regulator. I've had cases where the taxpayer, having settled, has been held over a barrel by the trustee for inordinate fees in order to then release the loan. Well, in that case, I think that is a matter for the regulator in Jersey or Guernsey. If it's a question of the loan having been passed on under a commercial arrangement or as part of the original arrangements, you need to look very carefully at the DR legislation, because it may well be that further relevant steps have been taken that you're still within the scope of the charges. It makes no odds that the loan's been transferred on.
I think the point is that the revenue taxing it as earnings doesn't change the fact that loans have been made out of trust, and I think that's a general misconception that's out there. As was explained earlier, the taxation point arises when it moves from employer to trust, but that doesn't say that all the steps afterwards didn't happen. And in fact, the Supreme Court in Rangers was very clear to say that there was no suggestion that any of the contractual steps afterwards didn't take place because of that.
But the DR legislation is superimposed over, it is subsequent. It takes precedence over the Supreme Court principle in that sense, in that you can still have a situation where you've been charged on a general earnings charge under the Supreme Court in Glasgow Rangers principle, but still have a subsequent disguised remuneration charge.
I was just meaning in terms of it doesn't null and void all of the latter steps that happen, i.e. the loan. In a legal sense, the loan exists.
No, exactly, which is why you've always got to inquire as to and identify what relevant steps have been taken, and there may be a whole series of them. And you may at some point, if tax has been paid on an earlier one, get credit against the amount on which tax is due under DR on the later ones. Or if no tax has been paid at any stage, well, then that's where you do have a problem, because if you seek to apply the double taxation provisions, you may find that in effect you get relatively little credit. Depends on the amount of the overlap and depends on the amount of late payment interest outstanding on earlier charges.
If I can just add my own two penneth, my understanding of the background facts to this kind of question is that the Revenue's main argument, more political rather than legal, was these are not real loans. And in order to, what promoters have been doing is, in order to somehow give credibility 10, 15 years after the event to these being real loans, is that they've then either started asking for repayment themselves or passed it on to third parties who've been encouraged to ask repayment. So it's, in other words, it's a bit of reality being added to cover up the sham. So in a situation like that, those are the facts. What can you do about it? Well, my strong advice is to get advice from trust counsel, particularly who's able to advise in respect of the jurisdiction where the trust is resident, or at least where the relevant law is for the trust. That's my two penneth.
Can I just add that one of the mischiefs that I've seen is that highly regulated trustees in Jersey have been transferring the trusteeship, retiring in favour of the appointment of trustees in the UK, which surprisingly perhaps is a relatively unregulated environment for trustees. And it seems to me that where they are doing so under the terms of a trustee that was originally drawn up on the basis that it did not require the consent of the beneficiaries or any protector or any member of the class, that is a complete mischief, because it allows the trustees commercially to do whatever they like to protect their own position and secure ongoing fees.
There is something quite mercenary about the arrangements as well, isn't there?
Absolutely.
I think we're going to do one last question and then we're probably going to have to wind up. So Claire asks, is HOE the pivotal point of law which will enable all pre-2010 loans to be taxed or not?
Hoey is under appeal, isn't it, Keith?
It is under appeal.
Of Judge Gillett.
The decision I tried to take issue with when I ran the Higgs case. There were issues which I thought were incorrect. Higgs has looked at some bits in more detail, and I can't say too much about the Higgs case, but I would say that I think the strongest point is the credit, and that is something which might be looked at Hoey. There are good things in Hoey. Most importantly, it was clear that the taxpayer, Mr. Hoey, was not entering in this arrangement in order to save tax. And part of the revenue spin is this is purely tax avoidance, and now your chickens are coming home to roost. That's not why people, on the whole, in the contractors market, went into this. But they've been left picking up the pieces of other the mess left by the promoters and the revenue's incompetence.
Very often they were obliged to enter into it, weren't they?
Absolutely. They said, I want a job. Okay, well, you have to go to this umbrella agency or umbrella in order to sign up the paperwork.
I think in terms of the question, don't forget that Hoey, starts with council conceding that the money is taxable under the decision in Rangers. So I think in answer to the question, Rangers is actually the seminal case for saying that the money's taxable, not Hoey.
It's just whether or not the revenue can get their hands on the money.
Okay. I am aware there are still some open questions. So you've got mine and Thomas's email addresses. Feel free to email us or events@londontaxsociety.com, and one of us will get back to you. This, as I said at the beginning, is the first in a two-part series of events. So the debate is going to take place in September, and we're looking to get people from both sides for and against retrospective taxation to explore what the reasons are for and against implementing it in legislation. So we're looking at getting people from, correct me if I'm wrong, Thomas, Treasury, potentially Parliamentary Committee, and also some barristers as well.
We've got some names lined up that are both interesting and very informed on the subject. So let's put it that way.
The recording, if you would like a copy of the recording, then it will be on our website for all LTS members, and anyone else, again, email events@londontaxsociety.com.
There are slides.
I was going to say the slides will also be on the LTS website for members. I think that's it. If you have, as I said, any other questions, you can contact us. Our email and phone numbers are in the chat box. And otherwise, have a good evening and stay safe.
Thank you very much.
Thank you,
Keith,
everyone.
Thank you, Keith. Thank you, David.